Winning an injury case is not usually very easy. Insurance companies and large corporations will take actions to try to pay you the least amount possible for your injury claim. I've seen this firsthand. You see, I spent years working on behalf of insurance companies in Kentucky, defending personal injury claims in Kentucky courts throughout the state. To win an injury case in Kentucky, you must be able to prove another party was liable for your injuries and damages. Let me tell you the story of my past client, Gwen. Gwen was struck by a vehicle when she was a pedestrian, but what I'm about to teach you in this video will apply to any type of injury case, including automobile accidents, slip and trip and fall incidents, and any other type of Kentucky personal injury case. I was having just another day at my office when my office got a call from Gwen. My receptionist got several of the details about Gwen's case and then added me to the call. I have a vivid memory of my first conversation with Gwen. I could tell from our first conversation that Gwen was a very kind soul that had simply been at the wrong place at the wrong time. You see, Gwen was hit by a vehicle at night in downtown Louisville, Kentucky. During my first conversation with Gwen, she told me there was probably nothing I could do for her as she was likely at fault for the accident. She only called because she wanted to make sure that she 100% positively did not have a case. Gwen admitted that she had drank some alcoholic beverages the night of the incident before the incident had occurred. She also admitted that she was in an argument with a family member when the incident happened. She knew very little details about the incident, like if she had the right of way, as she did not even know if the crosswalk light was signaling to her that it was safe for her to cross the street in the crosswalk. She did not recall being in the argument with her family member who was on the sidewalk she was departing, and that she was crossing at an intersection on or at least near the crosswalk. She admitted to me she was caught up in the argument and not really paying attention if it was safe to cross. She did recall being in an argument with her family member who was on the sidewalk she was departing, and that she was crossing at an intersection on or at least near the crosswalk. She remembered making it a little bit across the street when she was suddenly struck by a vehicle. Her injuries were significant, but Gwen was lucky it was not worse. She was fortunately still alive. As a result of her incident, Gwen suffered patellar fractures in both knees, along with a fracture and partial tear in her right shoulder. She also sustained lacerations to her head, knees, and hands, along with experiencing headaches, neck pain, back pain, and pain in both shoulders. Fortunately, she did not require any surgeries to treat her injuries, but rather her treatment included physical therapy and pain management treatment. I felt awful for Gwen. I knew it was possible Gwen's case was a loser, but she was such a nice person, I wanted to do everything I possibly could to help Gwen. When Gwen became my client, I told her to focus on her medical treatment. Well, I found out everything I possibly could about her accident by investigating how it happened. My team and I began investigating her case after Gwen became a client. We contacted all the businesses with offices near the intersection of where Gwen's incident occurred to see if they had any surveillance footage that caught the incident on video. After several communications with the nearby businesses, we were able to track down 2 separate videos depicting Gwen's incident on video. It was crucial we be able to prove at least some negligence against the driver of the vehicle that struck Gwen if we had a chance of recovering any money for Gwen. I already knew that based on what Gwen told me, there was a chance 100% of the liability for the accident would be placed on Gwen. And if that happened, Gwen would get nothing. I remember watching the surveillance videos. The first video I watched showed a side angle of the incident. In this video, I was not able to tell if Gwen had the right of way I could not see the crosswalk light in the video. I also was not able to tell if the driver was crossing the intersection on a green, yellow, or red light, as the traffic signal was not pictured in the video. However, several things stood out to me in the first video. 1. Gwen had clearly been in the intersection for some time before being hit, having even almost cleared the driver's lane of travel. 2. The impact flipped Gwen into the air. 3. Despite Gwen being clearly in the intersection, it was obvious the driver did not slam on his brakes until he struck Gwen's body. I could tell this because his brake lights did not illuminate until after his vehicle impacted Gwen's body. And lastly, after slamming on his brakes, despite traveling at least what I would estimate to be the speed limit of 25 miles per hour, he was able to bring his vehicle to a complete stop mere feet after slamming on his brakes. This video helped Gwen's case. It was clear I now had some arguments that the driver was at least partially at fault for this incident. And per the law in Kentucky, that is good enough, but more on that later. Despite Gwen clearly being in the intersection, the driver must not have been paying much attention to the roadway at all, or he would have been able to slam on his brakes and stop well before striking Gwen. I also watched the second surveillance video that depicted Gwen's incident. This video was taken from the other side of the street. I watched as I noticed that Gwen was well in the intersection and in the driver's lane of travel before he even entered the intersection. I also noticed that the driver's light turned yellow as he entered the intersection. While Gwen should not have been crossing the street at that exact time, the driver still should have been using caution and seen her with plenty of time to brake. Instead, he struck Gwen, flipping her body into the air, a very scary incident. These videos were all I needed to piece together an argument that the driver shared some liability for this accident. I knew on a good day in court we may only be able to prove that the driver was up to 50% at fault for the accident, but that is enough to win an injury case in Kentucky. You see, Kentucky is a pure comparative negligence state. That means in Kentucky, one can recover for their damages from any party deemed any percentage at fault for the accident, but you are limited to only collecting the percentage of your damages that the party is deemed to be at fault by a jury. Thus, in Gwen's case, if we could show the other driver was 50% at fault, Gwen would thus be entitled to 50% of her damages against the driver. Even under the facts of Gwen's incident though, I knew deep down that if Gwen's worst day in court came true, she could get nothing for her claim. This was in the back of my mind before we began settlement negotiations with the driver's insurance company. Gwen wrapped up her medical treatment after a few months of medical treatment. My office then gathered all of Gwen's medical records and bills. I sent a written demand to the driver's insurance company to kick off settlement negotiations. After several rounds of negotiations, we ended up settling Gwen's case for $75,000. If we could have proven the driver was 100% at fault for the accident, we certainly could have gotten Gwen more money. But on a good day in court, if the case had to go to a jury trial, we estimated we would only be getting maybe 50% of her damages against the other driver. So Gwen decided to take the $75,000 settlement rather than risking it and possibly getting nothing if we took her case to court. This was a win. It was certainly better than getting zero for her claim. The big thing to take away from this for anyone with an injury claim in Kentucky is that you can win your injury case in Kentucky and obtain a settlement even if you are partially at fault or even mostly at fault for your accident, so long as you can show that another party at least has some fault in causing your accident. As I stated previously, Kentucky is a state that has pure comparative negligence laws, which is the best type of negligence system in the United States. If you can show another party is at least 1% at fault for your damages, you are entitled to recover damages from that party up to the percentage of your damages that that party is deemed at fault. If you've been injured in an accident in Kentucky, do not automatically think you cannot win your case because you were at fault for the accident. If you do some digging around, you may just find out another party shares at least some of the fault for the accident, and if that happens, you can win your Kentucky injury case. The thing is, just because you now have discovered evidence suggesting another party is at least partially at fault for your accident, it does not mean the insurance company will offer to pay you a fair and reasonable amount to resolve your injury claim. You see, it is often the case that you must file a lawsuit to get paid a fair and reasonable amount for your injury claim. And in this video about to pop up here, I'll tell you why filing a lawsuit usually gets you paid more in your injury case. Lastly, if you've been injured in a car accident, slip or trip and fall incident, or dog attack incident in Kentucky, remember to don't wait, call Tate.